Kareem Abdul-Jabbar effect. He don't have to be on the court. All he got to do is be in uniform. The other team's going to change the way they play the game because he's got on the uniform. That's what we have to do. You have to outthink them as defense lawyers. You have to outthink them because all you want is a fair trial for your client. Okay, a couple more things, I'm going to sit down. You soften the ground, you challenge the array, you have your Batson motion in writing and already ready, and you have, I don't know if they're still required, I haven't practiced law in a while, I can't think of what it's called, but I had a motion with blanks in it that I would have on my desk. So if they struck John Willie Earl, I would request an additional strike because they struck John Willie Earl, which locks in the error. There's no way to get around the error. If you say, I was going to put I was not going to strike John Willie Earl and John Willie Earl was going to be a juror. Because they impermissibly struck John Willie Earl, that gave them 11 strikes. So give me another one. They're going to deny it. I don't have these cases. The reason I mentioned myself is I had them and I went off and left them when I left home. There's a case called Leroy Spencer Green versus the state of Texas that was tried here where Chip Cornelius and Brian Raines were the prosecutors against a TSU law student. I represented the TSU law student. Before Batson, you will see me raising hell about the fact that there was no name Batson. Swain versus Alabama was the law if you've gone back and studied it. Swain versus Alabama said that unless you could show a pattern where they did it, where the prosecutor did it, in every case, regardless of the facts, regardless of the circumstances, you couldn't make a prima facie case. Batson changed that. My point is, if the lawyer in Kentucky that represented Batson hadn't made an objection, notwithstanding Swain versus Alabama, then Swain versus Alabama would still be the law, lawyers. Don't ever accept what is. If you feel in your heart it's not right, say something about it. Do something about it. Make a record. When you go in the courtroom, don't expect to have but one friend, and that's the court reporter. You don't need the judge on your side. You don't need the bailiff on your side. You don't need the clerk on your side. You don't need a damn thing on your side. You need a record. But you get to make the record. That's what you do. You have these motions ready, you lock in the error. Another thing, I don't know what they still do it. When I was practicing law down here, they want to take the list back at the end of the they want to take the strike list back. I wish I brought the case. I'm going to give it to Alex and let him spread it around. There's a case out of the San Antonio Court of Appeals that said that statute is misinterpreted. The clerk does not have the right to ask you for the strike list back. If you give up the strike list, then how are you going to be able to look back after the trial is over 2 weeks later and be able to figure out some basis on your motion for new trial, which you should always file? Never give notice of appeal in open court. One example, I know it's off the subject, but it's important, I think. I was trying the case that a guy named Marvin Joe Finnis, who was charged with shooting a police officer over on Westheimer, right there in the curve where that restaurant is. And jury gave him 37 years, which is a real odd number. So after the jury left, I got the bailiff to go with me, went back in the jury room and emptied out the trash can on the table. On a piece of paper, they had written down how much time they thought he was going to get in Dallas for the shooting of an extraneous offense that Judge Huey let in over my objection. They wrote down how much time they thought he was going to get for the crime in Dallas, deducted that from 99 years, and they came up with 37. Well, you know, in the charge it says you should use no method of lot or division or addition or subtraction. That's proof prima facie right in the document that they had written, that they had violated the judge's charge. If I'd given notice of appeal in open court, none of that would have been made a part of the record. Never give notice of appeal in open court. I don't give a damn how mad you are about it. You got 30 days to do it. Take your time, somebody might call, one of the jurors might call you 3 or 4 days later. All that stuff you want to get in the record. I know that's off the subject. One witness rule. There's no such thing as a one witness rule. You let these prosecutors get up there and say, if the lady's at the bus stop by herself and nobody there's at night and she gets robbed, can you convict on the testimony of one witness? There's no such thing as a one witness rule. I'll give Alex the case on that to spread around. The law says if every element of the offense can be proven beyond a reasonable doubt. But they don't ask it that way. They make it seem like, because they want that gets rid of the so-called soft people, see. If you can't convict on the testimony of one witness, then you're really not a prosecution. You're not really a prosecution juror, you know. And they use that to try to strike you. There's no such thing as a one witness rule. Now let me get back to what I was supposed to talk to y'all about. I talked about the census data, the shuffle, objections to the peremptory. Get somebody to sit with you. Another example, I was trying the case named Johnny Fraser Johnson. Most of these people, you never forget their names the rest of your life. You remember their names the rest of your life, especially if you represent a capital defendant, you'll die remembering their name. So I'm trying this case in the 178th District Court over there, and my method is to start over here. I start with the first juror. I'm going to ask everybody some questions. They done got to the point now they give you some time limits. I don't know how that would work with me, but so I ask the question. I move down to the next person. And it's not like show of hands and all that shit. I'm going to look you in the eye. If you got a chance on being on my jury, me and you going to look eye to eye. I don't care if it's subterfuge. I realize we got to be soft and tip around because we can't piss off the rest of the panel. Y'all know that. You can't make everybody mad. You can't talk about race directly and all that kind of stuff because you're going to make somebody else mad to think that's politically correct. There's no such thing as politically correct. Anyway, so about the third row, I'm talking to this gentleman right here. And I moved to go down to the next person. And I saw this asshole elbow the person next to him. I'm not talking about you, asshole. I saw him elbow the person next to him. Tell me one reason why anybody on a jury panel, when you finish talking to them, would elbow their neighbor. Because they think they done got over on you, right? What other reason could there be? To elbow your neighbor, somebody you've never seen before in life, when I finish asking you questions and I move my head, my attention is diverted, and I turn to talk to this man who's next. That's why you have somebody sit with you, in addition to the reason that Alvin said. Maybe they just sit through jury selection, go about their business. You need another set of eyes and ears and another brain there with you. Do that every time. If you have to beg somebody or trade out with each other to do it. Jury selection is the most important part of what you'll ever do for a defendant charged with a crime. You win it or lose it right there. If you don't got the right jury, I don't give a damn what your facts are, you're going to lose. Jury selection is the most important part of it. It's the most important part of it. Another thing. Oh, I hate to use the word I. When I was in the legislature, I wrote the statute that determines Batson. There was no Batson. I sat many a day outside and watched all the black people get up and leave when jury selection was over. And I cried on the inside because it's not right to eliminate any group. All the white men with beards, all the Hispanics, I'm not talking about you, brother. Any group, a fair cross-section. Ebony magazine had a picture one time that's worth 1,000 words. It was a picture of a black judge, black bailiff, black clerk, 12 black jurors, black prosecutor, black defense lawyer, white defendant. It don't take but that one picture to tell you what the game is. Turn it over. This is not about black and white. This is about y'all representing your clients. And the best people to do it, I think, are the ones who won't be expected to do it. Because you catch them with their panties down. Because they know they expect it from me and him and the others. Why shouldn't they expect it from every one of us? Because we want a fair trial for our client. And maybe it's just a question of what is murder with malice or manslaughter, whatever it is. We want all of the community to be involved in the process, because when they don't, I don't give a damn what the result. You leave the courtroom with a bitter taste in your mouth. Because in the back of your mind, you know that it wasn't a fair trial. But if they do, and there's a cross-section, I don't know, for you, it's a whole lot easier to accept whatever the verdict is if I know there's a fair cross-section of everybody included in the process that end up on that jury. Two more things and I'm going to quit. Rehabilitation. There's nothing that says that you can't attempt to rehabilitate. Now, when I was practicing law, one of the questions there was, they took advantage of the fact that they think a lot of black people are real religious. And so they would kind of have some little trick questions they had, like, those questions about, you ever been treated poorly by a police officer? Can you be fair and all that kind of stuff? You get them up, you get a chance to rehabilitate them. Use your brain. When you get them to approach the bench, when you're making that record, in addition to making sure that their record reflects what ethnicity, race, gender, whatever we use to divide God's children from each other, blue, orange, whatever, that's made a part of the record up there. But why you have them up there? Say, Miss Smith, now I know you said that you didn't think you could be fair because that time when Junior got arrested by the police and you thought he got beat up a little bit and everything like that. And I know you were honest in answering the question, but let me just answer this for the judge. If you believe beyond a reasonable doubt that John Willie Earl over here is guilty, and you've taken an oath to a true verdict render, you're going to lie on your oath? Turn it around and stick it up there. They're not going to lie on their oath. That's the point. They take an oath to a true verdict render. When you get them up there out of the presence of everybody else, you can rehabilitate that juror. You can make a record. Now, the judge might go ahead and say it's not pretextual and let them go, but you got a record for the Court of Appeals that says, notwithstanding all the other things that I said, when it came down to the ultimate question for any juror, which is, can you give a fair verdict? Will you put all that other stuff aside? You notice the judge always asks on the ones that we want to strike, can you put that aside? We're asking they do. They do it all the time, Mary. Yeah, I know, you don't like black people, but can you put that aside and give John Willie Earl a fair trial? And if they say yes, the person's still on the jury. Well, not just black, it's in everything. It's not just, I'm just using black and white because that's the easiest example to use, but all the little subtleties they're talking about. Use your brain. Y'all are smart, y'all are young, y'all got all these fancy gadgets and stuff. Y'all can find ways to combat this. This is a war. This ain't no game. This work is not for everybody, and you know it. But if you're going to do this work, if you're going to wake up in the morning and look yourself in the mirror, whether you shave or not, know that you've done the best you can for the person that you represent because they don't deserve any less. Look at, when Batson was decided, to show you how things are, when Batson was decided in April of 86, wasn't it? 86? Right. Long time coming. The question was whether it was going to be applied retroactively. Read a case, a United States Supreme Court case called Allen versus Hardy, Hardy. That's the case where they decided it would not be applied retroactively. But if you look at the original opinion in Allen versus Hardy, you'll find that the issue wasn't argued, it wasn't briefed, it wasn't even part of the appeal. The Supreme Court, because there was such a hue and cry from across the nation, which means that we know we've been discriminating. We were discriminating based upon Swain versus Alabama. Now you're going to apply it retroactively to all these people that are locked up in jail somewhere who didn't get a fair trial. Had a case in the Supreme Court at the time. A lady rode down here on the bus from Dallas to see me. Didn't know me from Adam. Showed up in my office. God sent her. So her son is within 2 weeks of being executed. When Batson was decided, I got a stay of execution. They ultimately executed him. I didn't represent him at trial anywhere, but Dallas was, in Texas, one of the worst places. Everybody knew that Henry Wade had in the manual, strike all the black people. So we know we can make a prima facie case if it's applied retroactively. So they decided it was not applied retroactively. There's a man named Ed Dowd, who's dead now. He was a prosecutor. We were picking a jury in the 183rd case, Phelps versus State. We're picking a jury. Robert Jones was a law student. You all right if I tell this?
Tell anything you want about me.
Robert Jones was a law student working at Grocery Supply. This black guy that was on the jury panel worked at Grocery Supply. On the lunch break, I called Robert Jones. Hey, man, I don't even remember what the guy's name was. I got him down here. He's answered all the questions right. All those death penalty, Witherspoon was the law back then, questions right. He's qualified on the death penalty. You think I ought to take him. I'm scared of him because his answers are too good to be where I think he ought to be. Robert said, take him. So they strike him. We could smoke back in those days. We stood out in front of the courthouse with Ed Dog. We were standing out there smoking a cigarette. And I was really pissed off at him because I thought he was a good dude. He was from Connecticut, didn't grow up in Alabama, the South, no harm to Alabama, anything like that. I was really pissed off that he was the kind of white brother that would strike a black cat like that. And he says, hey man, I wish I could have taken him, but Jack Botiford told me to strike him. Jack Botiford was the chief prosecutor. The unique thing about it was that when the man, juror, walked in the courtroom to take his place, as you know, in a capital case, you get to sit on the witness stand. The venire person is examined from the witness stand. Jack Botiford got up and left and never came back. The significance of which is he only knew that he was black. He didn't listen to one question he answered. I put that in the record. That's in the record in the Court of Appeals. And then he said, and I sit down, he said, man, I told you that in confidence, and you used it. There ain't no confidence. This man's life is at stake. The truth was, I put him on the witness stand and made him say it. You don't apologize to anybody. If you're down here representing somebody's life, the hell with that other stuff. You ain't got no damn friends. That's all I got to say.
You want to say something else?